This is the Nursing Home Abuse Podcast. This show examines the latest legal topics and news facing families whose loved ones have been injured in a nursing home. It is hosted by lawyers Rob Schenk and Will Smith of Schenk Smith LLC, a personal injury law firm based in Atlanta, Georgia. Welcome to the show. Hello out there, and thanks for joining us. My name is Rob Schenk.
And I'm Will Smith.
And we are Georgia trial lawyers, and we just so happen to be your host for the Nursing Home Abuse Podcast. Welcome, and thanks for joining us.
Thanks for joining.
Lots of good things on the horizon today. A lot of interesting topics to get into. Before we went on air, we were talking about the television program Hollywood Squares. I think that my favorite Hollywood Square was she was on Scooby-Doo one time. She was a comedian in the 60s and 70s, and by the 80s she was completely crazy. Mm-hmm. What was her name?
I can't remember any of those hee-haw Hollywood Square.
Phyllis Diller. Her name was Phyllis Diller. Yes. I think Phyllis Diller was my favorite. Like, I didn't understand. I just know that if she seemed like she would have been a part of our family. You know what I'm saying? Like, she's kind of crazy. Like, I think she smoked a bunch of cigarettes.
Oh yeah, she absolutely did.
But she was on Scooby-Doo.
Who was the guy that was like the middle square that was clearly at the time, because of social conventions, was closeted, but everybody understood that he was on Johnny Carson all the time.
The guy that throws confetti?
No, not that guy. There's like two or three of them. Anyway, I can't remember his name.
Okay.
So that was
good.
That was a great story.
Anyway, what I was going to say about Hollywood Squares is that I feel like because as we record this, we're looking into a monitor. And I feel like we are, you don't call them contestants. We're guests on the Hollywood Squares program. You see what I'm saying? Like, because we are appearing as we do this, we're looking into the camera, but our camera is attached to a monitor. And I feel like I should be saying, like, X gets the square or something like that.
I can't wait till this is finished.
Well, you made it longer than it should have been.
Okay.
We could have just quit with Phyllis Diller, but you had to add yours.
All right. Well, let's...
Anyway, lots of good things aside from this on the podcast today. A question that we receive often is, how do we mediate a nursing home claim? So in other words, if you or your loved one has been injured in a nursing home and you might not necessarily want to go to trial, or there's the advantages and disadvantages of filing a lawsuit and going that route, what does it mean to mediate a claim? Mediation is an alternative to filing a lawsuit and taking a case all the way to verdict. It is an alternative dispute resolution method. And like I said, the alternative to litigation. Mediation generally is done at the leisure of the parties. Oftentimes, though, sometimes it's mandatory and obligated by a judge. So, for example, if you've already filed a lawsuit in a case, sometimes the judge will say you got to go mediate this. And sometimes it is obligated by contract. So, for example, if your loved one has signed an arbitration or mediation, a contract that has that in the actually nursing home abuse contract, I'm sorry, the nursing home contract has mandatory mediation or mandatory arbitration, then you're obligated to mediate in that instance. But most often, and particularly with a lot of the cases that we have, the parties will choose to mediate rather than go through the normal conventions of a lawsuit. So mediation is where, from a logistical standpoint, the parties will go to one location. And oftentimes it starts off in where the parties are all in the same room. So I'll paint the picture for you. Oftentimes it is a long conference table. You're going to have the mediator, who is a neutral person to the parties. In other words, it's somebody that has no dog in the fight, that has no stake in the claim. The mediator oftentimes is picked by mutual agreement of the parties. Depending on how the mediation gets started, the parties will say, hey, I like these 6 people, 7 people, and then the other side will say, I like these 6 or 7 people, and whichever one matches up, they'll pick that one. Or maybe somebody will suggest, one side will suggest somebody, and somebody will say yay or nay to that. There are different ways that you can pick the mediator. If the mediation is occurring through private company, so for example, if your loved one who has signed a contract with the nursing home to mediate a claim, it's generally going to be through a particular company. So for example, the American Arbitration Association, or somebody like a company like JAMS. They are private companies that happen to employ private neutral mediators, and you'll have to select a mediator from their stable of mediators. But at the end of the day, the mediator is going to be somebody that has no stake in the claim, that's going to hear the argument. So anyway, so back to the painting of the picture. There's usually a long table. The mediator's at the end of it. Your loved one, if possible, or you, the family members of the loved one, and the attorneys are on one side, and then on the other side is generally going to be the attorney for the nursing home, oftentimes a representative of the insurance company that has a policy covering the nursing home. And then oftentimes, and it's a good sign, it's a sign of good faith, that the nursing home administrator or some representative
or director of nursing yeah,
is present as well. So you'll have a lot of people in the room. And what happens at the beginning is that usually the mediator will start off by saying something along the lines of, we're here to try to get this settled. It's confidential, blah, blah, blah. They'll go through the ground rules of what the mediation's all about. And I mentioned confidential, and we'll talk about that a little bit later. But then generally, it's not a time to argue the case at that point, but generally the floor is given to the plaintiff in the case, the person that has been injured in the nursing home, to lay out facts, lay out argument, lay out what the position is of the injured person from an overall standpoint. And that can be as simple as a 10-second statement. It can be a 30-minute video. There's all different kinds of ways in which the person that has been injured, their side is going to open the mediation through some type of statement. The purpose of the statement, oftentimes, again, like I said, is not to argue the case. It's not to persuade somebody. It's just to basically a couple things. One, to get issues off the chest of the plaintiff. Second is to enlighten the mediator, because sometimes the mediator only receives position papers or knows very little about the case. Sometimes, sadly, doesn't know anything about the case. But to educate the mediator, and to, I find for our clients a lot of times, because if the client so chooses, we allow the client to speak if they so choose. Most of the time they don't want to, because it can be kind of nerve-wracking, but it allows them to get things off their chest. And then after that, generally the plaintiff or the injured person, the person that's bringing the claim, goes first, and then the defendant will go. And the purpose of the defendant setting a claim is to, reveal what their position is from their standpoint, from their point of view. And oftentimes, the opening statement by the plaintiff and the opening statement by the defendant can be emotional, as you can imagine. Many times, the family of the loved one, they already feel guilty because they feel like it's their fault that they put their loved one in the nursing home that ended up severely injuring or killing their loved one. And then you have the nursing home attorney who's in the position to say, we acknowledge that there's been a death or severe injury, and we're sorry about that, but we're not at fault. And that can be very contentious. Generally at trial, you're separated. The parties are separated by several feet, or an entire courtroom, and you don't feel like it's confrontational in that sense. In the mediation, you're 3 feet away from the individual that may or may not have been responsible or liable for the death of your grandfather. So that process can be contentious, but it's absolutely necessary for the parties to I guess, feel out how the mediation is going to go. After that, generally, the parties will, the attorneys and the clients, anybody there, will retreat to separate rooms. We call that caucusing. Not caucusing like what they do in Iowa every 4 years, where, I don't know, how does that, Iowa caucuses, New Hampshire primaries.
Mm-hmm.
Yeah. Anyway, you what's called caucus, meaning that the parties are isolated from one another for the rest of the period unless the mediator so chooses to bring them back together. And the point of that is to allow the mediator from that point to go room to room to talk to the parties. So generally how it works is that by the time you've gotten to mediation, one party, the ball is in their court, so to speak. So for example, if a claim or a demand has been made on a nursing home for an injury, the demand is saying, we'll take $1 million to settle this claim. The nursing home might have responded with, we don't think we're liable, we'll give zero. Or maybe the nursing home has responded by saying, we'll give you $200,000 to settle the claim. So you have the ball in that instance would be in the court of the plaintiff making the demand, because the offer was $1 million. The nursing home has come back with zero or $200,000 or whatever it is. So generally the mediator will start with the parties who need to make the next move. So many times, at least in our experience, we're in mediation because the defendant, the nursing home, needs to make the move. So we've usually gone back and forth once, and we go to mediation, and we have an offer on the table that they need to accept. So therefore, the mediator will start with them, and the mediator we are not going to be privy to the conversation that the mediator is having with the defendant at that point. And then the mediator will talk to them about everything, and they'll come back to our room and say the defendants or the nursing home in the situation is going to offer this much. And then, as you can imagine, it goes back and forth. At that point, the job of the mediator becomes a facilitator of a settlement through the process of being, in my opinion, a psychiatrist and being a counselor and being a therapist. Because the settlement is generally going to be a great idea for both parties, because trials can be sometimes arbitrary in outcome. So the job,
and like we have discussed in episodes past, when we did a couple weeks ago, they can be very, very long and time consuming. Mm-hmm. I mean, it's not going to be something that's over within a year. It could take years.
So the job of the mediator, in being a psychiatrist, being a counselor, being a therapist, is to oftentimes talk sense into one of the parties, or both the parties. But sometimes an insurance adjuster can be hanging on a specific fact that makes no sense. And even though they have being represented by a great attorney, that attorney cannot convince them otherwise.
The adjuster is the one with the pocketbook. She's the one that's got the checkbook.
Correct. So the mediator's job is going to be to say, listen to your attorney, or see the facts as they really are. It's a bad idea to hang on this. It's a bad idea not to come down or to come up on this amount of money that you need to offer, that kind of thing. So the mediator acts as the kind of, I guess, ray of light, the wisdom, brings the wisdom to the table that, there's somebody that can be believed, and that helps. And that's for both sides as well. So, because the job of the mediator is to make sure that both sides leave with the settlement. So sometimes that goes on, the back and forth. Sometimes we've had to walk out of mediations. Most of the time, though, we facilitate a mediated settlement.
And something that people, I understand the conspiratorial fear that a lot of our clients have. Well, who's this mediator? How do we know that he's got our best interest in mind, or that he's not in cahoots with the defense because they brought up his name? A mediator would not make a living if he were not well liked by both the plaintiff and defense bar. So it's not like a judge where you're going to say to yourself, "Oh no, I drew this judge and he's really against plaintiffs, or he's really, against defendants." You are all both agreeing on the mediator because he or she has a reputation for fairness and understanding.
That's right.
Because you don't have to go with that mediator.
Right. And so the mediator is going to sometimes not just be a messenger of numbers. The mediator is going to be someone that offers suggestion to either numbers or some type of resolution to the lawsuit. Mm-hmm. So they'll come up with numbers, or they'll come up with ideas about, hey, what if they changed this or this, or what if they apologized, things of this nature, because they want to facilitate a settlement. So oftentimes the mediator will succeed in that. And so what happens at that instance is that you have basically a binding contract. So for example, the nursing home is going to agree to pay $800,000 due to injuries that your loved one has suffered. So what happens is that they're paying $800,000 for a release, meaning that that the plaintiff, your loved one that's been injured, will not sue them for the same injury. So basically $800,000, and we call this a day type of situation. And that is enforceable by a court of law. So you do not have to worry about, if you're considering mediation, if your loved one's been injured in a nursing home, you don't have to worry about a nursing home or insurance company not paying after you've settled at mediation, because it becomes a binding and enforceable contract at that point. If for some reason, we've never had this happen in however many years we've been doing this, an insurance company say, we're not going to pay. But if they did, then you go to the court and say, we mediated this settlement. They agreed to this. Sometimes you call the mediator to testify, and you get your money, and that's how that works. So you don't have to worry about they said this day, tomorrow they'll take it back. That's not how it works. It becomes binding and enforceable against them and you.
And if you're thinking to yourself, or if you want to point out that if they refuse to pay and you have to go through the court system again, it's going to take even longer. That's just a reality. But again, I have never heard of that happening, and I have never had that happening. That would that'd be an extreme situation.
Right. So, but at the same time, if the mediator is not able to bring the two parties together, you're not obligated to accept a settlement that you do not want. You can always get up and leave a mediation if you so desire, even if it was obligated by the court. If your position is that they're not coming with good faith, you can get up and leave.
And that's an interesting thing to bring up too, is that, and this is another aspect of various states and their tort reform. In Florida, and understand that I'm not barred in Florida, and I'm not really up to date on how this has been shaking out, but it was the case in Florida, and I think that it still is, that before you could file suit in a nursing home case, you had to attempt mediation, and that was appealed to the Fifth Circuit. This is just to tell you how old this was, and they decided sort of in the favor of plaintiffs, but it was still a requirement that even if you filed suit, you would have to engage in some mediation. Luckily don't have that here in Georgia. We tend to try to do mediation.
And we have many judges, and if you draw that judge,
DeKalb, I know they'll do that.
And Cobb, I mean, you have judges that just if you file a lawsuit and you get that judge, your standing order is you have to get mediation. You have to go to mediation.
The problem with a statute like this one in Georgia, like this one in Florida, was that it was at one time a condition precedent to filing a lawsuit, which meant that before you filed a lawsuit, before you got discovery, before you had access to all the questions that you wanted to ask this person or this facility, you had to mediate, and you were essentially going into mediation blind, which is what we don't like to do.
That's right. So there are, as we've mentioned, there are several benefits to mediation. The first benefit, as we've hinted at, is the time factor. Mediation is at a time frame that you decide. Essentially, it's whenever you and the other parties are able to, and the mediator are able to meet in a room. There's not 2 years of motions practice and discovery. It's basically, do you want to work this out? All right, that sounds good. When are you available?
I would say that you're generally looking at, let's say that it's January 1st, and you want to mediate a case. You're generally looking at a 3 to 4 month window to coordinate both attorneys and the insurance adjuster, and especially the mediator, because if you're picking somebody that's really good, they're going to be really busy. So if your mediator has every single day free from now until April, there's probably a reason for that.
That's just a general amount of time. I mean, you can mediate something in a week if you wanted to.
It could absolutely be.
Yeah, like I said, it's at the schedule availability of the parties involved. That's how quickly it can move, and that's how quickly it can be done. Like you could feasibly, this hasn't happened in our experience, but you could feasibly do opening statements into mediation, and the first caucus settle it within 10 minutes. Generally, I find that ours gets mediated towards the end of the business day.
Well, I won't say it almost always. In every single case for us, it has taken all day long.
Yeah, it takes all day. And sometimes we leave mediation and it gets settled a week later just because. But anyway, that's a benefit, is that you save a lot of time, okay? Another benefit is the cost factor. So in litigation, there are many, many costs that you might not think about or anticipate. For example, paying an expert $10,000 to provide his opinion, or the $500 in filing fees, or the thousands of dollars in deposition fees where you have to pay a court reporter to come and type transcripts up. With mediation, I mean, those can, a case can cost, a medical malpractice case or nursing home negligence case can be anywhere from $50,000 to $250,000 in expenses. With mediation, sometimes you can bring in, if you so desire, if the mediator wants it or if it's necessary, you can bring in experts to testify or to speak, and that costs money, but generally it's going to be just the parties. And if that's the case, then what you're paying for is only the mediator's time. And mediators cost anywhere from a few $100s an hour to maybe a couple $1,000s an hour, depending on how good they are, and that fee is split between the parties. Generally, sometimes you can negotiate that one side pays as part of the settlement. But anyway, so time cost. From the standpoint of the nursing home, an advantage is that the proceeding of a mediation is confidential, meaning that anything the nursing home says, anything that any party says, is going to be confidential and not able to be used later down the road against them. So while a deposition taken in a lawsuit is public record, or could be public record, the proceedings of the mediation, what is said in opening statements or during caucus, is never going to be public record. It's going to be private.
And this is an issue that I have with mediation versus verdicts. I mean, I will always tell my clients that at the end of the day, for them, it is best to settle these cases if they get a fair settlement. But
that's a big if the settlement is fair.
If it is. But it's a problem for the public at large that so many of these nursing home cases are settled confidentially because the public never really finds out what happens. And even though the family may have complained to DCH, as we talked about in a couple of episodes back, the imposition of civil monetary penalties is slight. It is toothless. And Georgia is extremely backed up. We have an enormous backlog of complaints. So, at the end of the day, this nursing home pays some money and never really gets in trouble. But, you got to do what you got to do, and the insurance company that insures this nursing home sure isn't happy, and so that makes a difference as well.
That's right. So, is it ideal that cases are settled confidentially? Probably not. But at the end of the day, the purse strings, that is, the insurance companies, are certainly keeping track of the money that they're doling out, and many times that in itself almost is self-regulating. Not really, but that's what we hope. But anyway, speaking of nursing home self-regulation. A question that we often get as well is, how do we seek out a nursing home that will be right for our loved one?
I get this question a lot, not just because I'm a nursing home attorney, but having worked in these places, people are always asking me, what do you think about this place? Have you ever heard of this place? Because what I usually tell people is, if I've never heard of it, that's probably a good sign. But yeah, there's a lot of online resources that you can use to look at and compare nursing homes and assisted living facilities for your loved one.
Yeah, and in terms of just from a general standpoint, searching place out, we've covered in previous podcasts that it's really a multi-step process. Definitely, you want to go and investigate personally, put eyes on the facilities, and we've talked about that, doing the sniff test, the smell test. But one thing that you want to do is, where you probably want to start, is an online search. And there's many places online that you can go and look in terms of selecting a place based on how it's doing in terms of scoring. And one of those places is eldercare.gov. Eldercare.gov has basically a locator, which is the Eldercare Locator is a public service to help older adults and their caregivers connect to services, including long-term care services supports. So you can go on that website and basically peruse the different facilities in your area. Or there's a number you can call, 1-800-677-1116 for information.
I will say that I think that there's a lot of different websites. The best one to go to, though, is nursinghomecompare.gov, which is the official CMS website for nursing homes which receive Medicare and Medicaid.
Medicare.gov/nursinghomecompare.
Yeah, /nursinghomecompare. If you type in Google nursing home compare, /nursinghomecompare.gov comes up. So it also has state and state agency reports on the nursing homes, so that you can look at those for the past 3 years and see what fines they've paid, see what reports were made, see what deficiencies were cited, and that's extremely important as well.
That's right. Speaking of deficiency, we have
deficient time to continue, but
this is almost like we're like the Beastie Boys. Like, you're finishing my rap lines. You know what I'm saying? Like, it's kind of throwing me off a little bit.
Yeah.
But you're right. We have a deficient amount of time left for this podcast. We've come to the conclusion of the podcast. You can catch the podcast in multiple ways. You can watch it on our website at nursinghomeabusepodcast.com.
You can download an audio or MP3.
You know, I don't know. It's been a long morning for us here. But anyway, we appreciate that you've tuned in, and new episodes are available every Monday, and we hope to see you again soon. Until next time.
Until next time.
Thanks for tuning in to the Nursing Home Abuse Podcast. Please be sure to subscribe to this podcast on iTunes or Stitcher, and feel free to leave us some feedback. And for more information about the topics discussed in this episode, check out the show website, nursinghomeabusepodcast.com. That's nursinghomeabusepodcast.com. See you next time.